Which, good morning, everybody, and welcome to Senate Economic Development, Housing and General Affairs. This morning we are continuing to address housing. We have to get this bill out if we can today or tomorrow. So we're closing in on a couple of key issues. And we're also going to be addressing our cannabis bill, which has to be out next week. So we're going to begin discussing our protected our public accommodations aspect to our housing bill and to for our protections for renters. And I would just like to begin because we asked the judiciary to weigh in on this. So before we turn to Angela, because I think Cameron isn't here at the moment, but which is too bad because I was hoping we would walk through, but Cam is going to represent what the committee felt because we sent it to the Senate Judiciary for review. And I just want to read you what Nodder said. Nodder says our committee, he's the chair, our committee, oh, there's Cam. Nodder says our committee was generally supportive and no changes were proposed. We discussed the possibility of completely prohibiting any instance of landlords or lenders engaging in differential treatment based on immigration status, but learn more about the preemption that would likely occur as a result of federal law. We also discussed some concerns about potential landlord liability under federal law. But after we discussed the details further, I believe those concerns were assuaged. So that is Nodder. And Cam, if you'd like to add anything further on how Senate Judiciary felt, but they were generally supportive and felt that our concerns that that because we acquiesced to federal basically preemption on some of this, that's fine. Would you like to elaborate on it at all?
I'll just mention, for the record, Cameron Wood, Office of Legislative Counsel. I'll just mention we primarily spoke about and focused on the two subdivisions D and E that are being proposed in the unfair housing sections. So for draft 3.1, if you have it in front of you,
we go to page. It's section. It's a section
all the way down on page 30.
Sections 11.
It's section.
Isn't it section 11?
14.
Oh, it's now section.
On 3.1, it's section 14.
Okay, and that's page
30. And it's the addition of subsections D and E, where, if it's required by federal law, verification of immigration status or differential treatment shall not constitute a violation of that section. There was conversation about, if the citizenship piece goes into the unfair housing practices, is that going to prohibit landlords from inquiring about someone's citizenship status in renting dwellings? And I told them, I think an argument will be made that yes, that if the landlord were to inquire about someone's immigration status at that point with the state law change, that would potentially be a violation. However, this provision was put in to ensure that if federal law changes and that becomes a requirement, that it wouldn't be a violation of state law. And then same thing with E, as we've talked about a little bit in here with the banking concerns about being able to take into consideration someone's immigration status in regards to determining whether or not to approve the issuance of credit, and federal law specifically authorizes them to do that. I would advise you to have a similar provision in state law so you don't have a preemption issue potentially.
Right.
If that would come up. That's primarily what we just talked about.
And this is what has allayed people's concerns.
I cannot speak for others. I think it has some of their concerns.
Yeah.
Yes, ma'am. I think some are okay with the language. House General was obviously okay with the language. You have Senate Judiciary telling you that they're generally supportive.
With these additions, they're supportive.
Yes, I think there could be others out there who still have concerns, but I will not speak for them.
On that cue, we're going to turn to Angela. Welcome back to our committee, Angela. It's good to see you.
Thank you.
And I can't recall if you have met our two new members, Tom and David.
Hi, Angela. I'm Tom Chittenden. I represent the southeast quadrants of Chittenden County. Nice to meet you.
Nice to meet you.
Good morning, Dave Weeks, representing Rutland County. Good morning.
And Angela has long been a very productive partner working with this committee on landlord issues and housing issues. And so we welcome your testimony, Angela.
Great.
Weighing in on sections 11 through 13.
Great. Thank you very much for the opportunity. My name is Angela Zajkowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization for housing providers. I'm also a practicing attorney. In my private practice, I represent housing providers primarily in eviction cases, but in also fair housing matters. And I have been doing this since 2003. So I have a lot of access and experience with sort of the issues that housing providers are facing around the state, renting apartments, dealing with sort of the exit when there is a problem, and sort of all things related to this industry. This particular bill amendment with these sections 11 through, I think it was 13, are sort of broken down, I think, into two different components. So we have this Social Security number issue, which is section 11, and then we have sort of the fair housing issue. So I think I might take them in reverse order because I think the fair housing issues might be a little bit more straightforward and easier than the Social Security number issue. I had raised concerns with the immigration status inclusion in this language. I think the exemption section D and section E that were being discussed, I think go a long way to help alleviate some of those concerns. But it still puts landlords in a very precarious predicament. When landlords are screening applicants, they're looking to see, is the rent going to get paid? Are the lease terms going to be complied with? And if you have somebody who could vanish or could be removed from the apartment very quickly or without notice, that creates some unpredictability for the landlord. And I think is a part of the process of screening folks. I think there's also a lot of concern given what we're seeing at the federal level. The way this is written is if required by federal law. I think we've seen some action that maybe by the federal government that is not in compliance with federal law, but still leaves people in a position of then having to deal with the consequences and the fallout of that. And I think it's a very hard position that housing providers are going to be put in with this issue. They're in the business of providing housing, but they also don't want to run afoul of enforcement actions, whether they're warranted or not, from both the state and the federal, right? It creates this conflict between state law and federal law and or federal actions that could have our housing providers caught sort of in the crosshairs. And I'm not sure that's where we want to be as we're trying to encourage people to produce more housing, make more housing units available. This type of situation, I think, has the potential to cause a contraction with some of our housing units. The more uncertainty that is imposed into this relationship and created, the less likely people are to make that ADU unit, to put another unit online, to offer rentals in general. And so I think, the state has to be mindful of that and careful that we're not inadvertently creating a situation where more units are coming offline because people are like, it's too risky for me.
Thank you. And the Social Security, or are there any questions about that section? Okay, and the Social Security issue?
So
the section is a Social Security issue.
Social Security is
11.
section 11,
Section 11?
page 24. Yep.
Yeah, on this in 3.1, it is, yeah, It's what?
It should be page 24.
Yeah,
section 11.
page
You
24.
got
Oh,
it,
there,
yeah.
20, on 25, actually.
Okay, great.
Can I ask one
What language is
question?
that?
Yeah, sure.
Angela, I walked in when you said it would be conflicting with federal law. Often, I mean, I've been working on amending the Fair Housing Act in Vermont for over a decade, and states are generally allowed to depart upward in a sense. So, you know, the federal government sets a floor for what has to be considered in the Civil Rights Act. But I just wanted to clarify with you that my understanding is we would not be in conflict. We would have a stronger Fair Housing Act, which other states have as well.
Right. So I think my concern is that that has been the normal process when business was as usual with the states and the federal government. I think we have entered into this unprecedented time where our normal operating procedures are clearly not in play. When I was in House General talking about this issue, Chair Mahaley asked me, has there ever been any sort of historical situation where landlords have been prosecuted or faced this type of issue? And I said, no, but I think we've seen in the last 100+ days a level of unprecedented action and behavior that we have never seen before on a myriad of issues, right? And so I think that's part of the concern here.
Yes, and Angela had said that even with D&E, which on page 30, which are an improvement,
Yeah.
she is still concerned about if someone is taken, disappeared, detained, what happens to the rent payments and that, and that she has ongoing concerns about actions that could be taken despite having D&E in here.
Right.
I just want to like level set on where we are when we are saying that. So, you know, that right now, I mean, a landlord could give lots of different reasons why they aren't taking someone's application, aren't offering them a place to stay. And I would hope that your members, you know, aren't adding to the list, well, if this person gets disappeared, I'm worried about my rent. Or if the federal government decides to criminalize anybody who is an immigrant, even if they are a visa holder or a green card holder or a US citizen, is the Landlords Association saying that they want to be able to ask about someone's immigration status to avoid that kind of constitutional crisis coming to their doorstep?
I think what I'm saying is that with this particular issue, immigration status is a complicated, it's a complicated point, right? We have folks who are here with legal papers of a variety of different types, and I will admit I'm going to start getting off into areas that I don't practice in and I don't have experience with, but we also have folks who are here without those, right? And so I think there's housing providers would have a concern that they're now going to be forced to rent to anyone, regardless of whether they're here with a legal status or not, and what the consequences of that might be from the federal government.
Thomas, and then
Angela, that's one of my concerns, is that we'd be forcing landlords to rent to people, but my understanding in the process, landlords can still ask for references. Is that correct? And they can still use that as judgment as to whether or not they have enough stability or roots in the community to count on them being a reliable payer of rent. So are there other mechanisms that can be used outside of validating these things that will still exist for landlords to be able to ensure renters are less risky?
Well, I think that depends on what happens with this Section 11 in this bill, because I think that those requirements or that addition is going to create some challenges for landlords to screen with their normal processes.
So, good point. Given our time frame, let's shift to that, because we also have another witness that we want to have testify on this issue, who currently, I believe, doesn't ask for these things. So let's shift to section 11 and to the social security. So we now have 3 things people can ask for. Is that right, Cam, if you just review this?
So currently, yes, very quickly, the language that you have in section 11, it would, landlords have the ability, if you will, to request information from a prospective tenant to do things like background checks and criminal history checks, etc. My understanding is they primarily do this through a social security number. The original bill, H-169, had a prohibition, as it was introduced, had a prohibition on requesting social security number. Right. And so there was discussion in House General about, well, can you do a background check with information outside of a social name, date of birth, address, etc. And so the House General Committee wanted this language put in to ensure that people who may either don't have a social security number, are able to still apply, and landlords can do a background check without that information, and those individuals, wouldn't kind of be excluded at the application phase. And so they've settled on this, which would require a landlord to take one of 3 pieces of information.
Any of the 3.
Any of the 3. So they couldn't mandate that it be a social. So it would be either a social security number, an individual taxpayer identification number, which is what someone can get if they're here and don't have a social or are not eligible for a social, but they're still paying taxes, or a government issued, valid government issued identification. And then they wanted that to be included in the application, the information to be included on the application. So
Right,
very
so it's
quick
one of,
summation of the language.
so it's one of these 3 things, which is now a landlord can ask for one of those 3. And so Angela, sorry, Dave.
Alright.
So what
Okay.
if they ask for the social security number and the applicant says, I'll give you my driver's license?
They would have to accept that.
Right.
So they can't,
That's
with this
clear.
language, sorry, I'm gonna interrupt you. With this language, they can't mandate a social. They have to accept one of the following. So if someone said, I'm not giving you my social, here's my driver's license, Senator Weeks, as you mentioned, they would have to accept that.
Oh,
When
Randy,
you say an unexpired form of government issued, then what government?
It's not.
The government of El
So it
Salvador?
could- If it was a passport issued by that government entity, I would argue that it would comply with that section.
And from a landlord's perspective, Angela, would that be something that would be useful to a landlord in doing a background check or a credit check?
No. The primary piece of information that a landlord needs to run a credit check, and let's focus on credit checks because credit and background are slightly different. The only way to get a accurate credit report is with someone's social security number or taxpayer identification number. Those are unique identifiers for an individual. And any credit reports that are being run, assuming a landlord even has access to do it, because most of the providers for credit reports require a social security number. If you're trying to run a credit report with name and address, you are not going to be getting accurate information.
Right.
And I
Wouldn't
think
you run a check using the individual taxpayer identification number, is that number available to someone who is not lawfully in the United States?
that I do not know. I do not work in sort of the immigration world, so I'm not entirely sure.
Cam, do you have the answer to that?
I do not. I have received some conflicting information on whether
Okay.
unlawful individuals, can receive an I-10. I'm not sure. You have Kirby in the room who may be able to answer that
Kirby, are
question.
you able to answer that?
Kirby King, Legislative Council.
Thank you. I hadn't appreciated that you had come in and are sitting here.
As far as I know, it's not available to all immigration statuses, and so some people who are undocumented would not be able to get one.
So it may not be available to an undocumented person, but anyone who probably has legal status here, yes.
If you have a green card and some other statuses, yes, you can get one of those, but not if you're undocumented.
That's my
Okay.
understanding as well.
Tom?
This doesn't mandate that landlords conduct a background or credit check, correct? But may I ask Angela, is it the practice that 99% of the time landlords do conduct credit checks and background checks?
I think it is definitely more common than not. Are there landlords out there that do not do credit and background checks? Yes. But I think by far and away, the substantial majority of them are using these systems, particularly credit, as a screening tool for applications.
But wouldn't that, my guess is that is landlords who have multiple units and not smaller scale rent landlords.
No, I mean, the association has a credit checking
Makes it easy
service
for everybody.
that we make available for our members that they can use. And there are a lot of small landlords that use that service.
I know. So would you be kind of, okay, should you do something? Because I'd just love to have you finish your testimony on, because
Sure.
we also have Chris Donnelly, who I want to have weigh in.
Sure.
But here's the question.
Well, I mean, I really think we need to get to the bottom of this because this
Yeah.
will probably make or break some folks' consideration of these sections. Everything I'm finding online, I'm on Consumer Reports right now, says you can use a driver's license to access someone's credit report. When someone is accessing like short-term rental website, you can often put in a foreign government ID. We have a lot of students who have lost their status overnight as a eligible visa holder. This was the Middlebury case. I didn't know if you were wondering. So I think there are lots of other reasons people don't want to give their social security number. It's also why I believe we changed the renter rebate process and landlord certificate process. So you could verify information without having to have all your roommates' social security numbers. So, I mean, Vermont does tend to be a kind of like, you know, I don't want to just throw my social security number around place. People often access driver's licenses without getting a real ID.
I think not to.
Are you saying that your folks are telling you they cannot get someone's credit report without a social security number?
Yes.
If they
and
can, so I would imagine if they cannot do that, and they can, so if they cannot access someone's credit report, that could be a factor. Like we could word it so that if they cannot produce a legitimate credit report, then that is not considered discrimination. But if they can work with the landlord to produce a legitimate credit report without a social security number, that is the current practice that's allowed in the country.
So I think just to maybe help alleviate some of your concerns that you were raising, a lot of landlords have switched to online screening platforms. So tenants go out, they fill out an application, they put in all of their information. The landlord does not see the social security number. It is submitted through the system, through the background and credit checking process, and the landlord receives sort of the report and the application information with a masked social security number. So
can you name the top program used for that?
Appfolio.
App,
APP, Folio,
Yeah.
FOLIO.
yeah. So the app is called Folio.
Well, it's the program's called Appfolio.
Folio, okay.
Let me ask you a question on that.
Yeah, Tom.
Do you know if this application allows when a landlord wants to use it to make this an option, or does the app just mandate that you have to get this information for the background check? Is it only designed for background checks and so it
Yes.
would be moot? Okay, but the landlords are not obligated to do a background check with this language or in current
No.
state?
No,
Okay.
no, and I think
My guess is many will rely on references, which you referred
Right.
to earlier.
I had suggested, because it seems the issue that's trying to be fixed here is what happens if somebody doesn't have a social security number, it doesn't have a taxpayer identification number, right? We see this in student populations, professors coming from overseas. Like there's lots of cases where people don't necessarily have a social security number. And the suggestion was just say you can't deny an application based on the fact that somebody does not have a social security number. So the idea, or taxpayer identification number, the idea is find another way to screen them. But if you have a social security number, then the landlord has the ability to ask for that information to run the standard credit checks and background checks. And that seemed like a relatively simple solution for what was identified as the problem, which is if somebody doesn't have a social security number, how do they apply for an apartment?
Right. Cam, what were some of the responses to why did we end up with this?
I would direct that to House General.
Yeah, okay.
I don't know that I was there when they
So
were.
giving people options was more what people were interested in. And the A is obviously driver's license is included in the government issued ID. I mean, it's a whole range of ID. It could be another country's passport. It could be a driver's license. It could be whatever. Right.
Most things I'm seeing online say that there's always a way to do a background check, even with these systems. If they're a FCRA certified screener, then there's a way to do a background check or a credit check without a social security number. I imagine in places like California, they actually still have the need to automate a process to check someone's information without them having a social security number. So I think the nexus here for where a landlord's responsibility ends is they're not able to access a credit report of the person if that's required, not that they can't produce a social security number.
Right. So so Angela, have you finished your testimony? Is that pretty much?
So just still with section 11 there, excuse me, is a part 2 in there. So residential rental application shall inform an applicant that the applicant may provide any of those forms of identification. That places a affirmative obligation on a landlord that we don't see anywhere else in our landlord tenant statute. And I have some concerns about what happens for the landlord who doesn't know that they have to do this and doesn't provide this notification, and that this is a completely new sort of requirement on the housing provider community, that I think has the potential to create a lot of issues and challenges for everybody, both tenants and landlords, with this sort of disclosure requirement.
I could, ma'am.
Yes.
Angela, can you in either draft 3.1 or 2.1 tell us what page and what section?
Oh,
You're
she's
talking about?
on page 25.
Okay.
And it's
where?
it is subsection 2 of section 11,
Yes.
which is on page 25. So, Cam, you want to just quickly?
Yeah, it's very straightforward. It's as Angela mentioned, it requires, so, you have the B1, which says that a landlord, shall accept one of the following in order to do the check, but then House General wanted to ensure that the potential tenant applicants were aware of that as well. And so they added the subdivision B2, which would require the application to inform the applicant that they can provide one of the above forms. So it is an obligation of the landlord to ensure that information is on the application.
That they can provide any one of those 3 forms.
Correct.
But what if they're, I just worry about number 2, what if they're not able to do the background or credit check with the El Salvador government issued identification? So in order to conduct a background or credit check, I feel like this language is assuming that you'd be able to do that.
It does.
Yeah.
I am not the expert to testify as to whether you can or can't do that or how that works.
So California has this in law. They outlaw landlords from refusing rental contracts solely because the tenant is undocumented. There's a lot of legal precedent on not discriminating based on what is in the National Fair Housing Act, which is national origin.
Right.
So I'm just trying to look at the case law, and there's certainly language that can be put in that gives both the landlord and the tenant their rights. That much seems clear from looking at this. I'm looking at a Texas legal firm.
David,
I would just say that national origin really equates to citizenship, which no one's arguing about. It doesn't equate to immigration status. That's completely different topic.
And
So-
even for the taxpayer identification number, at least looking at the IRS site, it is available to someone who is undocumented.
I'm just going to, I can send this to people, but this is an article about what looks like until this moment, a more recent federal appeals court ruling in Virginia. Is that what you've,
Reyes.
what is that?
sorry, to
It
those,
doesn't say,
sorry, just, while we're looking at this, those of you who are here on cannabis, we have to get this bill out in the next day or so. We're hoping to get it out today, but it may be tomorrow. And cannabis, we have to get out next week. So we may go a few extra minutes because we also have to hear from Chris Donnelly. So this is an issue we really need to land in this bill. So
do people
bear
want
with us.
the court case that I think I haven't seen a more recent court case than this
Exactly.
article in 2024.
Yeah, and this is the court case you were referencing,
I'm
Ken.
assuming it is.
I for some reason it won't give me the actual name of the court case, but it's Waples Mobile Home Park in Virginia. And it says this second ruling leaves no doubt that landlords need not and should not even ask about their tenants' immigration status. Renting to undocumented immigrants poses no legal risk, but rejecting a tenant based on their immigration status could be a violation of federal fair housing laws.
So that's, Ken, what you've been looking at.
Reyes
one of them.
v. Waples, yeah.
Might I, Madam Chair?
Yes, Thomas.
If we were to eliminate the number 2, the requirement to put it on the form, and soften the first part of this, B1, to say not in order to conduct, but if a background or credit check is required by the landlord, they shall accept any of the following, as well as adding another clarity, which I think I heard Senator Rom Hinsdale saying, that it is not a violation or not a discrimination according to this chapter should a credit check or background check not being able to be conducted. That failure shall not be considered discrimination if it's used as part of the landlord's decision to not rent to somebody. Does that get us to a better place? Did I make any sense with that blathering?
I would want to talk about the first piece. The second piece, I don't know that you need. And I would.
Number
we would-
2.
The second piece that
Yeah.
Senator Chidden was talking about, in this sense. I don't see anything in the language that you have here for this to go into effect that's going to prohibit a landlord from making some sort of racially neutral decision about who to rent to. You must have a minimum credit score of X. And as long as they are applying that equally to everyone,
Right.
and they're not saying if you have a social credit score of X and if you don't, credit score of Y, that could be discrimination. So as long as it's equally applied and it's a racially neutral, justification for why they're choosing to rent to who they're choosing to, I don't think there's a violation here. So
To be clear, if they discriminate, but not discriminate, but if they choose to not rent because they can't do a credit check, that's not discrimination.
we're straying into an area that I'm just not an expert in, because I don't know a situation where you can't do a credit check.
Well, you do a credit check, but not get any information back because there's no record of
And
this
if,
individual.
right, and if the landlord is able to say, hey, this is gonna get very specific, very fact specific. If you're saying, I can't get credit information on you
Mhm.
because you just moved here from somewhere else, you're a student, visiting
Yes,
professor, some
exactly.
other reason, and you're saying, I can't get credit on you and I'm not accepting anything else.
Right, right.
I would
So-
argue as that person's attorney that you're discriminating against
Exactly.
me because of both
Exactly.
national origin, citizenship, and immigration status.
Yeah.
I'm gonna argue all three of them.
Angela, I'm honestly worried that you are at risk of incriminating your members because because, and hear me out on this. If many landlords will say, you're a student, you don't have great credit. I'm asking your parent to co-sign. I'm asking someone else in your life to co-sign who has good credit. That's usually the second step for a landlord. That is entirely legal and best practice. Anything you do that could end up disenfranchising one community, international students, because you're worried now that they might not get their rent if that student is disappeared, because though they have only student visas. If someone said, you know what, we're no longer taking student visas anymore, students who have green cards are on student visas because we're worried about the uncertainty of that. Right now, under current laws, that would be illegal.
Right.
So if
I
I
just worry for your members that you communicate this to them properly.
Angela, I know you.
Right, if I might, for the committee, and then I unfortunately do have to go. I had a hard stop 7 minutes ago because
I apologize, Chris, and we need to hear from
okay.
Chris, and then we need to turn to another subject.
That's okay. If I might suggest to the committee some language that I think might solve this issue based on the discussions that are happening right now is if an applicant for residential housing does not have a social security number, a landlord shall accept any of the following in order to conduct a background or credit check. A individual taxpayer identification number, or B, an original or a copy of any form of valid government issued identification. So it says we have the right to ask for that, but if they don't, here's things that you need to take in order to run this background check.
And what would you do with number 2?
I would strike it.
Yeah. Okay. Let's think about that. Cam, you've got that language. And let us, thanks, Angela. Thank you very much. More to follow.
I do really encourage you to make sure you're not giving your landlords information that could get them in trouble with current civil rights law.
My goal in my organization is to make sure people are following the law, federal and state.
Yeah. Thank you, Angela. Appreciate your time. Sorry we're over time. And Chris, could we just hear from you as well? And great. Thanks, Cam. So you've got that language. Yeah, great.
Usually the most uncomfortable seat in the building.
So that is the most uncomfortable seat in the building right there.
I'm surprised it hasn't broken in all the years.
They're actually paired.
You don't want people to get too comfortable here.
Thank you, Chris.
I disagree.
Chris Donnelly with the Champlain Housing Trust. Thanks for having me in. I think this will be pretty quick. We certainly don't discriminate based on any of the protected statuses, and we don't ask people for citizen or immigration status unless we're required to. So the second part of the bill, we're totally fine. We don't care where you came from, what you look like, who you are. We'll take an application from you and go through the process. In the first part of the bill, we at first blush gave us a little heartburn when the proposal said you can't ask for a social security number. We did a little bit more investigation. We found out that the provider that we use to do credit checks can do a pretty accurate credit check just with name and address, date of birth. So we would adopt. And I think certainly feel like in this moment, in this time, the more we can do to support all of the members of the community, we're happy to do that. And that's pretty straightforward for us.
Yeah, well, I appreciate that.
And I understand what Angela's saying about risk. We don't, I hate the fact that people are normalizing the term disappear. That's actually
it's frightening, isn't it?
Yeah, it's just awful.
That was Chile.
Yeah. So we're fine with accepting that risk.
Okay. And have you had to date, I assume, no experiences with with, your adverse experiences
No.
with not asking for any of these things has not been
No.
substantial?
No, we don't, you know, we just don't ask. And,
Don't ask.
we
don't
have,
tell.
well, you know, I think the economic pressures on people's lives are much more impactful than this.
Right,
And
exactly.
that's the number I'm concerned with.
I mean, if I were to generalize, like, situations we've both dealt with in Winooski, when someone wants to turn over their entire apartment, all of a sudden you meet a lot of immigrant families who are flying as under the radar as possible, who never made a late payment on their rent, never wanted to be, noticed for anything, and, you know, felt extremely lucky to have a place to live. And whenever we dealt with, you know, major building turnover situations, all of a sudden, those are the folks who are continuing to pay rent, even because they worry that withholding rent is gonna get them in legal trouble. That has been my,
No, in some ways,
100% experience with anyone who feels fortunate enough to have housing.
And what I've been told, is even, you know, even having the social security number on the forms can be a chilling effect for people to not even apply. And so, we're happy having a disclaimer. We'll
so you
adapt.
don't even have it on your application?
No, we do. We ask for it. We use it to do background checks, or not background checks, credit checks right now. If they don't fill in that box, we find other ways to assess whether there'll be a creditworthy tenant.
Right. Right. Any questions for Chris? Thank you. That's
welcome.
helpful. To land this, where are we? Cam, you've got some new language for us to consider. I know it's a little bit.
No, that's okay. I mean, I can draft something up in between our
Right.
break. 'Cause
Yes,
I'll be
'cause we
back
have a
here
break now
later this
coming up for
morning.
you. So there's a proposal that Angela has given us, to strike number 2.
But can I just,
Sure. It's page 25 rather. Page 25, beginning B1, top, near the top of the page. And so her proposal, and I think Thomas's as well, was to strike number 2.
I like what she said better. Yeah.
Yeah, and to, do you have that? Would you like to?
Yeah, we could draft it. I mean, it would say something to the effect of, in the event an applicant doesn't have a social security number, in order to conduct a background or credit check, a landlord shall accept any of the following, and then you would just include the other 2 pieces on there. The I-10 individual taxpayer identification number or government issued identification. It's just a slight
Striking number 2.
rewording of,
And striking.
and then that would be up to you. all.
wait, what was the other wording? Sorry, I was reading section 2.
It would be changing B1 to simply say if an applicant does not have a social security number, in order to conduct a background or credit check, a landlord shall accept any of the following, and then include A or B, A and B. I mean, it's a slight rewording, and it's just, it would be, allowing the landlord in that instance to,
Ask for something.
request the social and rely on the social, and then in the event someone doesn't have one, they must accept one of the other 2.
Continue the process of reviewing the credit or the risk assessment.
At first blush,
Say that again
So that allows them to continue the process to assess the risk of that potential tenant.
Right.
Well, you have a situation, obviously, in which the landlord presumably could say, I'm doing the background check and I'm also evaluating you against the other applicants, and I've decided to rent to another applicant, period. If the landlord keeps his mouth shut, regardless of what decision,
Exactly, right,
he's complying with the law.
exactly.
exactly. David, your thoughts?
I'm still listening.
I know some landlords that have difficulty keeping their mouth shut though.
Well, there, many of us have had.
Can we look at the sentence somewhere? Is it written down?
I can,
So I think,
Can
you
write
know
it
what, given our
within-
time frame, why don't you do that, come back,
sure.
and then we're moving back to housing at 11. If we could come maybe 5 minutes before 11, let's do that.
May I ask one other quick question
Sure,
of
absolutely.
you all? I was-
Thank you, Chris.
And just knowing that you're hoping to get this bill out
Today or
or
first thing, yeah.
tomorrow, right?
Yeah.
So you have draft 3.1, which
Yeah.
has some slight additions. I'm happy to talk about that at 11. The only piece that's not in here as of right now is the project-based CHIPS language that
Which
you
is
all
right
passed
now in
out.
Ways and Means, right,
Over there, it's in Ways and Means. Do you want
to
the-
reinsert it.
the
here.
version that you all passed to be inserted into this bill at present? Or I just wanted to make sure you were touching on that, because it's the one piece that simply hasn't been brought back in.
I would say yes, because if this is the bill we go to committee conference on, we need it to be
Yep.
part of the discussion for it to not be a defective report.
Well, I'm curious what their objection was, like why they.
No, they're working.
Oh, they're working on it. They're
This is
continuing to
the
work
bill
on it.
that-
This just ensures it stays alive again
Yeah.
as it crosses the
Yeah, I'm good
Nile.
with that.
Application.
I wasn't clear on where we.
We wanna
are.
add chip.
Adding CHIP.
Oh, I definitely want
Chip
to
is
add chip
not
to this,
this.
our chip, right?
Our chip.
Our chip.
Okay, so
Yes,
for the
the
next
answer is
version
yes.
at 11.
Thank you.
that's
Oh,
what
I have
would-
another amendment. Because the development soils will require that this go to natural resources regardless, I'd like to
And our
add,
appeals. too.
I'd like to add the wetlands piece from S-133 and the opt-out instead of opt-in piece from S-133. Those have been really,
Okay, we haven't
Critical.
discussed those at all, and we haven't really discussed those at all, and that is an SNRE, and if it goes to them, they can add that.
we can add it and then they can discuss it, but we can discuss it. We have time to discuss it.
Well, actually not today, but let's, if you could get us that,
I asked Cameron for it this morning.
okay, if we could bring that, we're gonna have to hear about appeals because we've got some time frame issues on the people that are testifying, and then we'll discuss it.
I just want to endorse what Senator Robinson
Yeah.
just said. Both those pieces are key to building more housing in many areas, and they're the crux of what's.
They may be, but as you know, they're not our jurisdiction. If this goes to SNRE, depending on what we add, and I'm hoping that's the plan, is that they can add that.
It's a shared jurisdiction. It
Yeah,
keeps housing, it's literally a buffer between what you can build and what has become a constructed wetland because other things were.
Right, no, and I know you have
This is
that.
a tier 1 issue.
For 11, I'm gonna add CHIP. I'm gonna make this amendment that we just talked about on the landlord piece for
Right.
you all to review. There's a few other sections
And
in
if you
there
bring
to take a look
Keisha's
at it. and we're gonna
wetlands
have one
separately,
for
that would be
3.
great.
Yep.
Great. Okay, terrific. Thank you very much. Great. Let's, so Michelle, thank you, Chris.
She's with me, she's on the waiting room.
There she is. Okay.
And here is the stack of cannabis. Actually, it's more.
Full stack. I think they call them pouches of cannabis.
Yeah.
Bags, right? Bags.
But Michelle's document is on
A
top.
little rusty, my college days. Jars, keeps them fresh.
Okay.
Goes
Lucy,
on
hi.
YouTube, I just admitted.
Okay. Michelle, we are yours.
Good morning.
We're gonna begin with the,
You should have a copy of a individual instance of amendment, committee amendment, draft 1.2.
thank you. Can everybody hear Michelle okay?
You hear me all right? Okay.
Wait, do we have 1.2 in front of us.
Correct. So I'm gonna, so this was a joint effort working with Kirby because Kirby focuses on the taxes. I'm gonna go through the things that are not tax related on this because he's got a more comprehensive picture as how it works, how it's working with the budget as well. So I'm just gonna go over the other portions, but I'll be here while staff is walking through and Kirby's talking to you about it. And also Chris is talking about the fiscal note. So is it okay if I share my screen?
Yeah, and I just want to preface, before Michelle starts, these are the amendments we discussed. These incorporate John Rogers' concerns that are actable on at this moment. And some of them are not our jurisdiction. They will go to, this ensures that they will go to Ways and Finance. So these, we have discussed, these are the proposals that have come to us from the CCB and John Rogers. Okay,
Okay. So the first instance of amendment, it has to do with the excise tax and where that goes, whether it's going to be going into the Cannabis Regulation Fund, which provides for the funding for regulation of the adult use and medical use programs, or whether or not it's going to be going to the general fund. And Kirby will talk to you about that. Page 2, second instance of amendment. This is replacing the Section 12 that is currently in the House proposal of amendment before you. You'll recall that there were some tweaks to fees there because the underlying bill creates a new license type, and there were some small little adjustments to fees. And then my understanding is that Lieutenant Governor Rogers had proposed changing substantially the fees as it applies to cultivators. And so I just took that document that was provided to the committee and made those changes. In general, for the outdoor cultivators, the fees are being decreased. For the indoor cultivators, those fees are being increased. And then mixed cultivator tiers, I will just note that it's generally a decrease, but there is this one here, a mixed cultivator tier 2, that is an increase. So I was not there for the testimony. I'm not sure why that one is increased, but I'm sure the witnesses can talk to you about that. So again,
you're moving ahead to all the indoor cultivator fees have increased, have doubled. Right?
Yes. Yes.
Okay, and this will go to finance for discussion on the fees.
If I missed this, I'm sorry, but is this to balance out the fees? And I don't think this is a good idea because we have a lot of neighbors who want to push people to grow indoors, and now we'd be making that more expensive.
I think the argument from Lieutenant Governor Rogers and some others is that they can grow all year long and that the economies are that they're much more productive, whereas outdoor operations are a lot more expensive. They don't produce as much. So
single season outdoor, multiple season indoor.
Yeah, that's my understanding, and that's this reflects.
It's more expensive to grow indoor.
Yeah.
But
excuse me, I haven't called on you, right? And you need to. Hi.
Hi, I'm Joshua Decatur.
Hi, Joshua.
Tier 2 licensing owner of Fayetteville.
Ask to be recognized first, and then I'll recognize
Sorry,
you.
I thought I was recognized.
No, it's okay.
I
No,
kind of gave me the eyeball.
Thank you, Joshua.
My bad.
Feel free to
Coming
respond.
from all sides of the table. So,
yeah, you have one chair.
Yeah.
Thank
sorry
you.
about that.
It's okay.
So, just want to clarify that indoor cultivation is definitely more overhead, but it is more productive. You know, we're a tier 2 mixed cultivator. We understand, you know, outdoor cultivation is very difficult in the state of Vermont.
And more limited in time.
More limited in time, less demanding on the environment. And also, you know, tier 1 small outdoor growers and folks are hurting right now. So we do generally see this as helping them. So even with our fee increase, we're here to advocate for things that are good for everybody. But definitely understand the neighbor concerns as well. So.
Yeah.
I just don't understand why we need to raise the fees.
To balance it out, so we take in the same amount of money, but basically draw more from the tier 1.
Right.
The indoor.
But we have a lot of cultivators, right? Like that's what we heard from
400.
We have 400 cultivators. We didn't build our financial model off of like a plethora of cultivators to this extent.
Okay,
do you all need this money to function? I mean, usually fees are fees for service. If you ask Carolyn Brannigan and what we used to do in Ways and Means.
So this was, you may have missed John presenting this, but this was John's proposal, and so we.
But I'm sure John doesn't care if we don't raise the other fees.
Oh, no, he does. He wants that.
It was pretty clear in
to
testimony
balance.
what the objective was.
Why to balance? That's what I'm asking.
Okay, Pepper, can you, or Gabe, respond?
For the record, James Pepper, Chair of the Cannabis Control Board.
Yeah.
The directive to me was to find a revenue neutral proposal that incorporates the kind of relative profitability of between the indoors and outdoor cultivators. So that's what this does. I mean, it is a pretty crude attempt at it, because all it does is kind of cut the outdoor in half and double the indoor for all the tier one. So the tier ones, the fee remains the same. That's our, of course, largest pot of indoor cultivators or tier one cultivators. So this, I think you'll see from the fiscal note that this is just slightly revenue positive, but negligible. So that was the directive. And of course, it does not, I say it's crude because it doesn't take into account the, all the startup equipment, the lights, the HVAC, the kind of temperature control, the electricity that it takes to run an indoor. So
Does the fiscal note have a number on how revenue positive it is?
Let's check it.
We're gonna have,
it's around 70,000. I think.
70,000. So you could cut something a little more to make it not revenue positive.
Right, yes. Yeah, if, I mean, 70,000, it's tough because what we don't know is, are these increased fees gonna push out indoor cultivators? Is someone not gonna renew because their fee just got doubled on the indoor side?
But that's what I mean. You can reduce the fees on the indoor side because you
could reduce them ever so slightly if you wanted to remain revenue
neutral, right?
Who did we hear from on the indoor side?
We are not, this is not our, we agreed to take this in as a pass-through to finance for discussion.
But it has an impact on the indoor cultivator businesses. That's our jurisdiction.
It is our jurisdiction. And I think you just heard that an indoor cultivator is fine. We have not.
We did not hear from an indoor cultivator.
We need to hear from this is Joshua.
Joshua Decatur, we're an indoor cultivator, so I just wanted to offer my voice.
Are you on the witness list?
No.
We have an indoor
So
cultivator.
the witness list was changed in the last minute.
I can commit that Senate Finance will invite some indoor, when we get indoor cultivators to testify on this.
I understand. I mean, having been on finance, your goal is probably going to be to make things revenue neutral and look at the numbers. Senate Economic Development is charged with looking at the impact on businesses.
Absolutely.
And I don't feel good at voting something out without looking at the impact on businesses.
I hear that. So we're just hearing, this is the first time we're seeing this proposal fully fleshed out. We agreed to hear it. That's why it's been drafted. So we will hear from indoor cultivators. Thanks. But this is the first thing. The objective was revenue neutrality. And we will hear from more, but we're happy to hear from one today. But we will hear from.
Can I still ask Pepper a question?
Yeah, Pepper, come join us.
The idea of cutting one in half and doubling the other, in my mind, based on the word of maybe a handful of outdoor cultivators, did you look at other scenarios than that?
To accommodate the relative profitability of each?
Was the relative profitability like an exact double?
No. I mean, I say it's crude because essentially indoor cultivators, generally speaking, can get 4 harvests for every one.
That's my question. How many harvests?
Right, and so that's why it's kind of crude. This is kind of every $1 of indoor space is 4 times the fee of the equivalent outdoor space. That's just the general framework.
They also have like electricity costs and I mean like so many costs to grow indoors. And I have seen, people be forced indoors by neighbors. I represent Charlotte. And they have to spend hundreds of thousands of dollars to transfer to indoor growing.
Right. It's my testimony that this proposal does not account for that. It's purely I told the Lieutenant Governor, you can't create a slope. Create very perfect, perfectly accommodated.
This was your best attempt at answering John's request.
That's right.
And the Pro Tem has encouraged us to incorporate this, as has John. So we are doing that, and we can absolutely have we have an indoor cultivator here. We have Michelle. Pepper, you can stay there if you want. Michelle.
Yes.
Hi. But Heidi says you have something that you wanted to add here. I think you need to finish going through the amendment.
I was just going to ask, actually, your 3 staffers that are here right now, we are all double and triple booked. And since we're running late already, I was just wondering if we could go through and do the walkthrough and talk about these, and you can get what you need from us.
What we need further, and we need further clearly an indoor and outdoor cultivator. Right.
Great, thank you so much. We appreciate it. So lots to talk about the fees there, apparently. So, I'm gonna move down to, page 5. And note that for the products language, this has changed from the house language, and this is that there's an annual product registration fee. And there's just a small tweak to the language there.
So
around-
what number are you on page 5?
I'm on subdivision 10 on
10,
page 5 on products, line starts on line 15. So there's a current annual product licensing fee of $50 for every type of cannabis and cannabis product. And the language here has just been tweaked a little bit from at the request, I think, of David Meckenberg and his clients. And the chair asked me to include this language, just that it would be essentially, it's a little odd, but it's a biennial product registration, but there's still the $50 per year. So I'm not sure how the board will then assess those fees, but it's intended to be revenue neutral, but the product registration would be for 2 years unless the board determines otherwise. And I understand that you already got some testimony on that.
Right.
So the rest of, sorry?
Yeah.
Yep. So the rest of that section is the same as what was included in the House proposal. So the third instance of amendment is adding 2 new sections to the bill, sections 15A and 15B, and this relates to the showcase event permit pilot. And I believe that James talked to y'all about this last week, the idea being that, so it would be time limited, it would be for a period of 18 months, so from July 1st of this year through the end of 2026. And that licensed retail cannabis establishments that are in good standing with the board could apply for these showcase event permits. There would be no more than 5 events that would be allowed during that 18-month period, and multiple retailers could participate. So it wouldn't just be like one retailer at this particular event. They have to be distributed kind of geographically throughout the state. So they're not all particularly like, you know, in Chittenden County or such. Top of page 7, you'll see subsection B authorizes the person to coordinate, oversee, and be the responsible administrator held at a defined access controlled location for a period not to exceed 24 hours, at which cannabis and cannabis products could be purchased and possessed. This does not allow for on-site consumption.
Right.
Subsection C includes the things that have to be in the application to the board. One has to do with getting approval essentially from the local Cannabis Control Commission or the local legislative body, so where that event would be held. 2 is partnership with a minimum of at least 3 licensed cultivators, because again, it's the retailers that are partnering with the cultivators. So the cultivators are using the retailers as a pass-through to kind of reach the public there. 3 is a security plan, you know, to address issues around intoxicated folks or people who are under the age of 21. Bottom of the page, subdivision 4, a product sale plan that describes how much and the types of cannabis and cannabis products that are going to be offered for sale, how they're going to be transported to the site, monitored, secured, displayed, and sold in conformity with existing laws around the sale of cannabis and cannabis products. Subdivision 5 is actual capacity and intent to administer and enforce and apply the required plans. 6 is proof of insurance. And 7 is compliance with any other requirements as the board may prescribe. Subsection D is deviation from security and sales plans or any type of product tracking and taxation requirements or permit terms is a violation subject to adverse licensing action by the board. Subsection E is there would be a $250 fee to apply for the showcase event permit, of which 50% goes to the host municipality and 50% goes into the regulation fund. And then subsection F's just some catch-all language that the board could adopt rules if necessary. I think they, as they've testified, they want to get this kind of moving, hoping that they wouldn't have to, but that would allow them to adopt emergency rules if they needed to.
So, sorry, this is a question for you and Pepper. Why would you adopt rules before a pilot was over? I mean, I'm just curious. I thought this was a pilot farmer's market showcase. Why would you be giving permission to the, Michelle, I know you need to go, so let's finish.
That's okay. Sure. So section 15B is a report back. So Cannabis Control Board is to monitor and evaluate the events authorized in section 15A and report to House Government Operations as well as your committee on or before January of 2026. I just note that that would be kind of in the middle. Like if, I don't know how many they will do this year from July 1st through the end of the year, but you just want to talk about whether or not that date works for you, because they would be able to carry it through to through 2026. But you may want a mid-report in the middle of there.
Do we want, or an update? Right.
A concise assessment of the benefits, challenges, and administrative viability of offering cannabis retail sales at events outside the confines of a retail cannabis establishment. And that's it for me. The fourth one has to do with the taxation effective date.
Got it. Okay, great. Tasha.
So I had asked Michelle to draft some language for excess funds to go to the LAOB. I'm not sure if she has to go, when it would be appropriate. More upset about sports betting advertising than anything else. I will say that. So maybe one day we'll change that.
Okay, Michelle, thank you. Any questions on this so far? Okay, then we're going to invite Kirby to come join us. Thank you, Michelle.
Sure. I'm going to stick on for a little while. I have a little bit more time.
Yeah, that would be great. And as far as I understand, CCB, I mean, the board, we're aligned in you're being okay with this at the moment.
Yes.
And you're going to weigh in a bit anyway.
Yes.
Yeah. Okay, great. Kirby, welcome.
Good morning. Kirby Keaton, Legislative Council. So I will be going through the first and fourth instances of amendment here.
Great.
It's on paper, drafting part, very small. There's one line at the bottom of the first page, but I'm gonna give you the background, which is a little bit more involved. And then I'm gonna head off to Chris, because he's the advanced background person for the budget.
He's just advanced, period.
He's just advanced.
Yeah.
So, I'm gonna be this morning at least. I'm gonna be basic. He's gonna be advanced. So
okay, but we need both.
So there's a change that would be effective starting next July, not this upcoming July, to how revenue is used here. But I'm gonna give you the background about fiscal year 25, which is what we're living in,
right? How
cannabis excise tax revenue is used, and then this upcoming fiscal year 26, which starts July 1st this year, and then what this does for after that. And there's 3 different versions of how it's used, slightly different from one another.
Right.
So we're living in fiscal year 25 right now. All revenue from the cannabis excise tax goes to the Cannabis Regulation Fund, and then the unexpended and unobligated portion goes to the general fund, and 30% of that is used for substance misuse prevention. So just
30% of the unobligated goes to prevention.
The way that the budget's built right now, that's moving through the legislature, for this upcoming fiscal year 26, there's changes, and also just from some things that had.
And just before you leave 25,
sure.
The 26 revenue was What?
17 million.
That's it for advanced band.
Okay, that's advancement, okay.
Yeah.
Right, just so we have a notion of the revenue we're talking about. I thought it was
Yeah. It
was 20 million, is that roughly right? What, FY '24 final?
Oh, FY '24 final. Yeah, I believe it was around 24.
That's what I,
Unexpended?
No, that includes the 6% sales tax as well.
Right.
I think it was 17 or 18 in excise tax.
So sales tax already is just going into the education fund.
right. No. It goes
Are we gonna talk about sales
to
tax?
after school program.
Okay, all the sales tax goes
Yeah.
into the after school
Right,
program?
that's right.
Okay,
But we're not talking about sales tax here.
okay, I just wanted to make sure I knew
No,
about.
but people just need to have the whole landscape.
Right. Okay, so that's fiscal year 25. 26, which will start July 1st. The expectation is that there won't be any further changes this session, and
Sorry, there won't be one.
there won't be further changes this session. So like, you still have time to change this, but that's not the expectation. The expectation is if things are left the way they are, all of the cannabis excise tax revenue is to go to the general fund, and 30% of it would be used for a substance misuse prevention special fund.
Is that a new fund that we created for this fiscal year, or did we have
That
this
special fund is being created by the budget.
this year?
This year.
So, but that's basically prevention. That's still going to prevention.
It's, yes, the same concept. It's just the budget is kind of setting up a different structure for it right now. Which would take effect July 1st of this upcoming year. Which
So
would be-
that's been done without committee in,
Done last year, right?
Mm-hmm.
We passed that last
we
year.
did this
Yeah.
last year and it's now being incorporated this year.
It's in
Yeah.
in the budget as passed by the Senate right now for this year.
Right,
But it was a conversation based on last year's bargain with the governor that.
right. I think that's, yeah.
I don't have all the background on that.
Okay, thank you. But it's basically going to prevention. It's just going into a specific fund.
Yes, it's setting up a fund for it as opposed to what's been done in the past where you have the spillover and then 30% of that is to be used for, now there's a special fund.
So beginning in FY '26, all the revenue goes to the general fund.
Yes, but with 30%, and it's not spillover in this case, it's 30% of the revenue
The total revenue,
is going to
not
that special
taxed.
fund. Yes.
except tax,
What?
except 6% sales tax. So when you
We're
say
just-
all
We're
revenue,
just
We're
talking
just
about
talking
the
about the
excise
cannabis excise tax right now.
yeah, okay.
Not talking about sales tax
or fees.
or fees. or
Thomas,
anything.
you had a question?
Nope, no, good.
Okay,
And then just one little footnote, that 30% number is to not to exceed 10 million. And my understanding is that it's not expected that that 30% would exceed 10 million.
at the moment.
Yeah. Or
It's always hard to put numbers in that may change.
Okay, so that's fiscal year 26. That will be starting this upcoming July and for the next year after that. Okay, this language we have now is for fiscal year 27. It would come into effect next July. And it's set up so that 70% of the revenue from the cannabis excise tax would go to the cannabis regulation fund, and 30% would go to the substance misuse prevention special fund that we were just talking about. So no more flowing through the general fund at all.
Right, which has been a request by all parties as far as I know.
What is our policy intent by avoiding the general fund?
I think Pepper's gonna address that. Do you want to step in right now and just in real time here?
I mean, I think there's really, the real situation is, we were created as an independent executive branch agency with this special fund. It was anticipated that the fee revenues, because you set the fees relatively low, would not be able to cover the operating expenses of the board. And so this construct was created where you would direct cannabis excise tax to the special fund, and that's where our budget would draw from, the kind of delta between our operating expenses and whatever the fees and administrative penalties brought in. this was somewhat of a controversial decision at the time, because, you know, a lot of people didn't want a cannabis control board at all. And, you know, how many positions is it gonna be? What's the actual tax revenue gonna be? How much is the cannabis board's budget gonna be? You know, all the unknowns. And so he put a sunset on that provision that directed excise tax to the Cannabis Regulation Fund. So now that's where we are right now, which is, you know, you have to decide whether you want to keep the existing structure, or you want to just fund our budget through the general fund, that kind of delta. The policy choice, really, I think for you all is, you know, I mentioned that this was a controversial decision to even have tax and regulate sales. I think there's plenty of Vermonters out there, tax-paying Vermonters that are paying into the general fund that aren't shopping in our stores and not benefiting from any of the regulations that we're enforcing or compliance. And do they really want to be supporting with their general fund dollars the Cannabis Control Board operations, or would you rather that the people, the businesses that are paying into this fund through their fees, and the consumers that are paying into this fund through the excise tax are the ones that are paying for that, our operating expenses?
Yeah, Madam Chair.
Yeah, Tom.
So by my back of the math envelope, that's about 10 million bucks we're sending over to you. What's your budget every year? What are you spending on the cannabis control?
6.5 million is our budget.
And what are you gonna do with the difference? You just retain that, or do we carve that back?
Yeah, you grab, at the end of every fiscal year, the whatever the unexpended thing transfers back to the general fund.
So it transfers from the Cannabis Regulation Fund back to the general fund.
General fund.
Is that one of those
Right.
reversions you're talking about? No.
This is a transfer.
This is a straight transfer, okay?
Would it look similar or the same to parallel the financing structure to DLC?
I think that's how DLC operates.
Yeah, I think so too.
So how does DLC operate?
Let's give it a chair.
Yeah, so this is not an area of my expertise, maybe it is for you. It's my understanding that DLC, when they collect money into a special DLC fund, and
Right.
it's an enterprise fund.
It's almost exactly the same.
Right.
They use the revenue to pay their expenses, to pay the prizes, to pay everything. The rest goes to the ed fund for lottery and to the general fund for liquor. So,
There you go.
oh, Thomas, thank you. So that I believe is what happens at the moment. So this is building on what precedent elsewhere.
So really that's it for my parts. You see the first instance makes the change for the Cannabis Regulation Fund, 70% of the cannabis excise tax revenue. And the fourth instance is to change the effective date, because the other changes taking place in this bill are effective July 1 of this year, but this section 2A we're adding that we were just looking at will take effect July 1st, 2026, because things are already set up in the budget process for the upcoming fiscal year.
Yeah.
So this will not affect that.
Okay. Yeah, Thomas.
The cap at the 10 million, why do we have that? Are we expecting sales pot to skyrocket or double in the next couple of years?
I think that's been in there from the start.
Okay.
And I think there was a policy decision early on to cap that.
And I think we'll address it when we get to that point. But I mean, that's why it's always interesting and challenging to put specific amounts into statute.
Do you have my LAOB language?
I do.
Okay. Did you want to talk about that now or later? While everyone's fresh on.
It has an impact on where the money might go. And we've begun to heard from the LAOB on what their request was. So, and you are channeling their request, I think, into your amendment. Is that right?
I think so. I think it's more of a foot in the door than I think they are requesting 20% of the.
Yeah, they're requesting
25%, which I mean, really, when we established all of this, we agreed that we should be using it to repair harm to impacted communities. But barring that, in this fiscal year, when people are anticipating certain revenues to go certain places, I think we drafted it so that they get any excess revenue above the forecast. Is that right?
So,
I have to go back and look at what we
okay,
drafted on.
so
Okay.
why don't we, do you want to just talk generally
That's
about
it.
it, and then we'll
Yeah,
talk
that's it.
specifically when we have the amendment?
Right now, it's excess revenue above the forecast.
Yes, I do recall that from what we worked on.
How much was that this year?
The difference is that they've recalibrated the forecast. Maybe Chris can speak to that, but it's likely to be less because they've now realized they had forecasted. So it's a real compromise for me. It might not be a lot of money. It's a way to say that they have become the kind of organization that brings all of the stakeholders together to talk about what the best way to repair harm is.
And I think actually the Appropriations Committee has honored where they are as an organization in their appropriation to them.
For
just
now.
to
For
further
now.
support.
I mean, that's very little money for the impacted communities.
I don't
So-
disagree. So just to repeat, your amendment for the LAOB would be that any
Excess revenue above the forecast goes to LAOB.
Is that commonly referred to as a waterfall? Like the.
Contingency fund.
Contingency funds. Would you want to cap it at something? Because what if we
No.
have a great year in pot sales?
Well, that would be great. That would mean that more people deserve to be reinvested in who probably aren't having a great year because usually people who are not just as impacted are the ones who are first in line.
So maybe, thank you for that, and we'll discuss it further once we have that amendment with us. But that helps. There are going to be other requests on this as well.
I would add that at the point at which we discuss it, the discussion also should include the purpose of it and how justified it is, because some of us are very uncomfortable.
LAOB.
Uncomfortable with
points of
which
view.
part?
About the entire purpose of the fund.
I think there are some concerns on my left about the entire purpose of the Land Access Opportunity Board.
Right.
But that we will discuss when we have the amendment in front of us. So thank you, Kirby. Any questions for Kirby at the moment on the 70% and on the effective date?
I guess one question I have.
Yeah.
Is on the overall piece of, that Pepper testified to regarding the decision to change the fees for indoor and outdoor cultivation. Did the board spend any time looking at it? I gather by just having it in both instances, just at first blush seems arbitrary. And the question is, did you really come up with numbers that said this is the right way to achieve what it is you were trying to achieve? Was there any study? Was there any detail? Was there any analysis? Or was it a snap decision?
It wasn't motivated. It didn't come from the board.
It came from Rogers.
Right. It was,
Well, that's why I'm asking, what did the board do? Did the board do anything with it aside from accept it?
What the board did was take the concepts, the priorities that the lieutenant governor wanted, and try and find a proposal that matched those concepts.
Can you spell out exactly what those concepts were?
Revenue neutral was first.
Right.
And then second was trying to accommodate the relative profitability between the kind of 1-to-4, basic 1-to-4 ratio between harvests. And the kind of also, generally speaking, outdoor cannabis, outdoor grown cannabis kind of caps out at around 20% THC, whereas indoor can go
much higher.
Much higher.
Yeah.
And so a lot of the flower that you're seeing being sold in retail is grown indoors, and a lot of the flower that's being grown outdoors goes to either extraction or to pre-rolls, and that's not across the board, but that is.
Who did you consult with besides the lieutenant governor before putting this out?
So when this sounded like the lieutenant governor was kind of saying that this is the proposal that he wants to see, I've spoken to the Ways and Means Committee every year. Like, we are now 3 years into this market, so in a traditional agency, this would be a good time to review our fees. They didn't have the time to do it this year, so they said, wait, come back next year. We actually do have economists under retainer right now that are doing a full kind of update to our market analysis that may, have some bearing on this.
So, I guess the question I'm really asking is, you made it at the request of the lieutenant governor, but is what you've done fair?
we will hear about that, I think, because
I'm
we,
asking what.
I think we should
what-
ask the Lieutenant Governor.
Yeah, we could ask Lieutenant Governor, but
Yeah,
I'm
we're
asking
asking
the
indoor
board
and outdoor
that's in
cultivators.
charge of regulating this, not in responding to what an official asked for. Did the board, in terms of looking at this, determine, is it from the board's perspective, a fair proposal for all concerned?
It's a fair proposal.
Okay, that's really what I'm asking.
I think you heard that actually from Joshua, who's an indoor grower. Joshua.
Am I recognized?
Yeah.
Joshua Decatur. I just want, there's some terms getting confused here. So one thing I want to stress is that outdoor cultivation is actually much more profitable because your cost per pound of production is very low. There's a difference between profits and overall income and consistency of revenue and cash flow. So I want to make that clear. There's some confusion here. Also, THC percentage, we're finding, we're a retailer as well. So I can also talk from that perspective, actually. We're finding customers are less and less driven by THC percentage as they get more educated. Testing right now is a little more complicated than that. So we see a very high demand for outdoor flower. I basically, look, we're privileged to even be in this room right now. So we feel we have an obligation to speak up in the context of fairness and what's good for everybody. I could be sitting here right now telling you all kinds of things. I could hire lobbyists and work through them. I could be petitioning to be one of those 5 events. We don't think that's fair. We don't think, so in fairness to outdoor cultivators, I want to recognize that they do only get one harvest a year.
Right.
And their cash flow is much more inconsistent than indoor grow. But in fairness to indoor grows, your overhead is much higher. You have huge costs through the whole year. So it's not quite that 1-to-4 ratio. I think there's good intent. What I meant to say is I thought there's good intent, but the realities are a little bit more complex. The economics of the situation are more complex. And I'm happy to open my books for the committee and show them that we're mixed. So we grow outdoor, we grow indoor, we have a retailer, we're gonna soon have a manufacturing facility. So we try to keep a fair perspective. And again, our company's keyword is integrity. We're here today to try to talk about what's good for everybody, not just work through lobbyists to look for the most advantageous situation for our business. We feel we have that obligation because we're privileged to even be sitting here.
And we appreciate that. Thank you for making the time to sit.
If I could just say the fundamental flaw in the methodology is the one you pointed out, that it doesn't take into account overhead costs to grow indoors. So until we have numbers that are produced with a much stronger methodology, it would be really problematic for us to endorse this proposal. And I don't know what in between would have the appropriate methodology at this late time.
So the conversation that you weren't in with Lieutenant Governor Rogers, I believe, was just that we wanted to add something so that we could continue the conversation and get it to finance to have this exact conversation. So it wasn't an endorsement of what was put forward. And that's what we're doing now, is just continuing it.
Well, it may well be that we do something for a year while the study that is necessary to determine the real cost equivalency of what we're doing. Because I don't gather that's been done.
I could see lowering some numbers because there's less harm in that, but I can't see vastly increasing anybody's fees based on the current methodology we have heard about. That wouldn't be good of us as former Ways and Means to do something like that. I take that very seriously. So at this point, I'd have a hard time endorsing anything that had numbers attached to it at all, as opposed to something that moves the proposal forward with a proposed methodology or just nothing, because you're already studying it.
With something that is a decision based on the gross appearance, based on what we know. We know, for example, in terms of what gets produced outdoors and what gets produced indoors, and we have some approximations, at least, of the trend that may not be balanced. And you could do something on an interim basis and then refine it.
But that you're outside, you're using sunlight and rain, and inside you're not. So, I don't think you can use one string of inquiry to get this right.
Right.
Well, I think we should hear from folks that we haven't heard from, and then move the bill.
Yes, so we're committed to taking some testimony next week on indoor and outdoor cultivators. We can look at this language and maybe we can come up with some language that, I think it's important that it be revenue neutral. I agree with the board. It has to be revenue neutral. And I think that let's look and see what we could come up with that would get us to finance that was a landing spot we could all get to. Joshua, you have one last thought on this.
But our job isn't the revenue neutrality. Our job is the impact on businesses.
I agree.
Yeah,
Joshua.
I just want to throw out there that this is also related to event permits, and event permits are really key to the whole health of the industry. We're here again advocating against our best interest from some measures to say that event permits should be accessible to everyone. That makes a big difference to the whole economy of the cannabis market at large. Just having 5 events exacerbates inequalities. We're going to watch the cannabis market, like in other overregulated states, shrink, which is already starting to do, the overall size of the market. And that is all related to these fees, because if you don't open up some sort of equitable and fair expansion of the market, which right now is extremely heavily regulated and favors retailers a lot, then you're not going to have people even renewing their licenses in a few months. You talk to anybody. So this is connected to all this stuff. And also the CCB is getting 70% of the revenue coming in, and that's related to this as well. So just want to point that out.
Good. Thank you. Kirby, anything else?
No, I think you're good with me. I think, were you planning to also hear from Chris?
Yep.
Can I ask one question, Pepper, or somebody?
Absolutely. And then we have a couple others, and we need to.
How much revenue did the fees bring in this last fiscal year?
I think it's right around 2.6 for this fiscal year.
2.6 million.
Right, and that includes the administrative penalties, so that's a minor part of it.
Okay.
So the revenue being generated absent the excise tax is.
Besides the penalties, is that like 0.1?
Yeah, it's less than 100,000.
Okay, so 2.5 million.
Okay. Let's pivot. Let's have Chris. Are you coming in now? Yeah. Here. Oh God, you're here. Oh, great. Perfect. And then we will go to Jeffrey and Graham and Gabe and Pepper. And Tim Egan, I believe, is here. Yeah.
Tim.
Great. Chris, thank you.
Well, good morning, everyone. Chris Roop, Joint Fiscal. I will start off by saying that I am not our in-house cannabis expert. My colleague Ted Barnett is out of reach this week, so I am trying to fill in for him and get up to speed on these issues. So
and I think we have these.
You
right
do.
In our.
You do. They're posted on the committee page under today's date. So that's my plea to please be merciful with me on your pointed questions. Before I get started.
So you don't want us to look at you as the advanced knowledge, but just the advanced man?
Yeah, I'd really much rather lower expectations, but you might hear, I don't know, but I'll find out a few times.
Great, so you want us to start on this one?
Yeah, I'm gonna start at that, but before I start walking through it, I just wanted to mention, I think it was Senator Chittenden who asked about the excise tax and the revenue forecast and everything. The current revenue forecast for FY25 expects 20.8 million would come in from the excise tax. That was actually downgraded from 22.2 in July of 2024. And through March, we've brought in about 15.2. So we're
So for the first quarter?
No, for the first 3 quarters.
I mean, first 3 quarters. I keep forgetting.
Yeah, so we're pretty much on track.
So the first 3 quarters were at what?
15.2.
Did sales go down in the last quarter?
Sales have gone down over the last year.
Yeah.
Sorry.
We have seen revenues this year flatline from last year. We're starting to see a plateau. And we have seen some months where year-over-year collections have been lower than they were the prior year.
And is Joint Fiscal feel comfortable analyzing the reason for that decline?
I think the market at this point is just starting to stabilize and mature. I think we're still pretty early for really understanding those insights. We haven't had the system in place for that many full years. But we always sort of expected things would not just continue to grow indefinitely. At some point, the market needs to sort of plateau and reach its.
It's hard to think about something maturing after only 3 years, but okay.
We're starting to see it go from very rapid growth to flattening.
Right.
But anyway, let's go back to the memo. The memo focuses just on the things that were in the amendment that you just looked at.
Right.
I'm going to sort of breeze through this because I think you already heard a lot of this and other folks already addressed what I would have, but I think based on the proposed cultivator fee changes, our estimate was roughly 44,000 to the good, which in the context of, $1.1 million a year in revenue from these cultivator licenses is, it's pretty close to revenue neutral. The proposed changes to the product licensing fees that you all heard about briefly, if there were to have that 2-year product license fee instead of the 1 year for $50, in the big picture, that's pretty much revenue neutral.
Right,
But,
that's sort of de minimis.
yeah, but obviously if you're paying $100 in year 1, you're not paying anything in year 2, so it is what it is. The proposed showcase event permit pilot, limit of 5 permits to be issued in a limited period of time. This is a de minimis revenue impact. And going back to what Kirby had just mentioned about the cannabis excise tax construct, I attempted to put the conversation into words here to sort of show you what the current law is, what the Senate budget does, and then what this change that is before you would do. So as you all know, in the current year in FY25, the 14% excise tax went to the regulation fund, and then the unexpended and unobligated balance at the close of the fiscal year gets transferred to the general fund. So there's a little bit of a timing lag there where the amount that's left over at year end close in 25 gets transferred over into 26.
So I guess what the question I have here is why, and Pepper, you maybe have to, or both of you, Chris and Pepper and Gabe can answer this. Why did we, if we had this construct already established, why did we change it to the general fund?
It was part of a political compromise.
Oh, it was part of the compromise with the government that we referred to earlier. Got it.
The direction to the board was come up with a fee structure that fully supports the regulatory functions of the board. And if that's impossible, recommend using a portion of the excise tax. So we gave you 2 proposals back in 2021 or 2022. One that fully supported us through fees, but our fees would be inaccessible. It would make the market relatively inaccessible.
Right. They'd be too high.
And so we came back with a second proposal that, gave, more realistic fees compared to our neighboring states and require a portion of the excise tax.
So while we're on that, the fees when we chat further about this, I think we'd all appreciate seeing how our fees relate to the states around us.
Sure. Oh, please, yeah.
That would be helpful to us.
Well, Mr. Roop is in the seat. How common is that configuration that I believe Senator Armento was contemplating on a contingency funding for the LAOB? Is that a common practice?
It's not very common. The one example that I can think of that is in our law off the top of my head relates to the estate tax, where if we're, I think, 125% above the July forecast, any overage in the estate tax goes to the higher ed trust fund. That's the one example that comes to mind.
But that is because that's so variable, right?
It is variable. And they don't receive money every year.
For sure. So than this, which is low.
They're getting money this year, though.
Yeah.
Lots of people died. Yeah.
We've been wondering what's been driving the numbers so high, but do you have any idea?
Well, if this federal administration doesn't give everybody a heart attack, it's sort of nasty.
But yeah, but in the year that you all are thinking about the budget right now in 26, under current law, the excise tax goes into the general fund. So beginning in 26.
And our proposal in 27 is to go back to the original, to the construct
to something a little more similar to that. But I just wanted to point out that in the current year, this money is factored into the revenue forecast for the 25 to the 26 budget that you all are currently building, which I think is why any changes would be prospective to begin next year to not mess things up too bad in the current budget construct. My next section here just walks you through what's in the budget for FY26. So you all will remember that the BAA has also been folded into the big bill. So there are some other changes happening in the budget that don't just pertain to FY26. So the number was updated. This was a BAA item originally. The transfer from the regulation fund to the general fund in FY25, I think we had originally assumed that'd be 12 million. The actual amount was 15.4. So that amount was just updated in the BAA to reflect the actual amount transferred at the beginning of FY25 based on where things ended in FY24. Beginning in the construct also has that beginning in FY26, 70% of the excise tax goes into the general fund, and 30% would go into the new substance misuse prevention special fund. So this is sort of accounting gymnastics. It's really not a policy shift. It's quite frankly, a sort of a cleaner way of executing the intent of dedicating 30% of this money for substance misuse, rather than sort of looking at it on a lag. The money would go into a special fund. This really doesn't have an impact to the general fund. There's some other things going on in FY26 related to the regulation fund. So the budget construct contemplates that in the general fund would receive 70% of the unencumbered and unexpended balance in the regulation fund at the close of FY25. That is in excess of 4.035 million. That is, jargon of saying the intent is to keep $4.035 million in the regulation fund at the end of FY25 and keep that in 26. For budgeting purposes, we would expect that the extra balance that would be available to come into the general fund in 26 would then be 8.9 million. There's sort of a similar construct with the substance misuse special fund, with taking that 30% of the unencumbered balance and dedicating it to substance misuse. The budget construct estimates that $3.8 million would be available for substance misuse then.
And are you conceivably booking that as we look forward to budgeting?
Yeah, this is all being built into the current.
This is all built into the budget, that additional 11 million.
Right.
Okay.
In 26, the budget that your colleagues.
So the FY26 budget is using this 11 million.
Yes. So the proposal that you all heard Kirby walk through was that beginning in FY27, 70% of the excise tax would go to the regulation fund instead of to the general fund under current law.
Yeah.
And then the unexpended and unobligated balance in the regulation fund at the close of the prior fiscal year would be transferred to the general fund. This would create a revenue shortfall in the general fund in FY27 due to timing, because of that lag where like the balance at the end of FY27 would then come into the fund in FY28. But the general fund would also presumably avoid the cost of having to fund the CCB net the fee revenue if the CCB is being funded out of the regulation fund and the excise tax flowing there, because without that, conceivably, they need to be fully funded somewhere. It would likely be the general fund. Long way of saying that things sort of net out if we make, and this is a continuing conversation that we need to have with other people in my office in some other committees, that we might want to take a look at some of this construct to make it look a little less like the current law with that lag, and a little more like how we do things with the direct apps from the enterprise funds, where the money gets credited to the current fiscal year rather than to the subsequent fiscal year. If we were to do that change, everything pretty much nets out budget neutral.
So this is still a work in progress.
It's still a work in progress, and we just need a little more time to figure it out. There's a lot going on this week.
Oh, no.
Yeah.
Really?
What's going on this week?
And so that is
Chris.
not something that should be done now.
So
yeah, I think
that's the
we can
question
do it
is
a
we
little bit.
have to get this bill out next week. Is that?
Don't let this stop you from doing that. We're going to continue working on it. This could be like one additional sentence that one of the money committees would need to add when the bill reaches there.
When you go over to finance, you can make that case.
Yeah.
Okay.
Or to approach.
So finance members take this on board. So noted.
There's also that's the memo. There's also a fiscal note posted for the underlying bill that I can pull up if you want, but it's really short.
We have it, and people should review it if we can before we.
Yeah, it's really short. Ted got it onto one page. I mean, the revenue impacts are de minimis, and the bill does create a new position that our understanding is.
Jennifer, you want to mute yourself and your speakers?
Okay. Great. Thank you. Thank you, Chris. I think just given our time and that we're gonna have everybody back in on housing at 11, I think let's go to Jeffrey and Graham and then Tim and then Jim, Pepper and Gabe. We may need to have you come back, but let's at least hear from Jeffrey and Graham and because they have amendments for us to consider as well.
Chair.
Thank you. We're
Good morning, everybody.
sorry. I mean,
Cannabis again.
we have to get the housing bill out this week. I mean,
Certainly.
I'm hoping
Let's do some
probably
talk.
not today, but tomorrow definitely.
And I wanted to take a moment, if appropriate, just to introduce, we did bring, one of them introducing.
Yes, we've already met Joshua.
So I want to take a moment to share that we brought some licensees with us. You all had met Amy Lenz,
Yeah.
previously, she had testified. And if appropriate, allow them to speak, join us.
So we have not very much time, and
Yeah, go ahead. And then we also have Ethan of Ethan Kramer of Tilia Hills. I just want to say that, Ethan, take a moment to introduce yourself, but one of the most talented outdoor cultivators in the state. These are individuals that, you know, we want them to survive the market and export this product, just like how we export like a $10.
Right. So I think given our time frame and given that we are going to be inviting indoor and outdoor cultivators back.
Okay.
Let
Certainly.
your proposals, and then we are gonna have to shift to housing at 11.
Okay.
And Tim would love to also make sure we hear from you.
Yeah, okay.
I just wanted to say, you mentioned housing bill, you know, Rural Vermont's a supporter of the housing bill, which does not require social security numbers. Vice tenants, we work on migrant justice and others, so we appreciate your work on that, recognize its importance.
Thank you. We have been working on it.
We came to this originally when we had about 4 or 5 minutes, first time we testified, saying how disappointed we were. And I have to say, seeing the bill today, that disappointment is doing nothing but growing. What we see is a bill containing proposals with those in power and not those with the greatest, who demonstrated the greatest public support and industry need. We see the defunding of the Cannabis Business Development Fund, the annual $5,000 usually goes. The CCB asked for 25% for the LUB, but now they're asking for 70% for themselves. And we're seeing further sales opportunities for retailers, which offers cultivators and manufacturers as mascots, essentially for those events with no possibility for profit share themselves. Senator Brock asked, is what you've done fair? And I know I'm not supposed to ask you all questions, but is what this proposal puts in place fair? Is what the CCB is offering fair? We would say demonstrably no.
You're talking about the fees,
We're talking about the direct, we don't need to talk about fees. That's a waste of time, to be quite frank. Like, we're talking about substantive market change. You reduce an outdoor cultivator's fee from $750 to $375. Is that going to change their ability to stay in the market a few $100s? No. That's why we're talking about, we came on April 16th with statutory language. We walked you into it. We only had a few minutes. We couldn't walk our way through it. That language has now been endorsed by 70 businesses and organizations, 9 retail licensees, 49 cultivator licensees, 10 manufacturer licensees, 10 social equity licensees, 15 economic empowerment licensees, 11 medical cannabis patients. None of these proposals come with any demonstrated backing. So I'm confused when we're looking at proposals. My question is it why are coalitions of grassroots member-based groups with bringing in expert stakeholders who represent thousands of your constituents not represented in the proposals being brought forth when our proposals were brought before anybody else's to this committee? Let's start there. Now we can get into our proposals. And I would say beyond that, you know,
Pardon me, Heidi. Thank you.
Oh,
Sorry.
I thought you were in.
Thank you.
I just want to also say, like, the last meeting.
Your speaker.
Thank you.
The last meeting here began with the chair saying we sent Director Cannabis Control Board off with many of the stakeholders to develop a proposal for amendment. What James delivered was a unilateral proposal. They refused to meet with us to talk about this. I wrote you all about this. You have a many-page document attesting to this. And what we did is go and seek out common players, bring them to a table, and try to reach common ground. It's not perfect. Our working groups were really hesitant to make any changes, but here we are. You've already seen the equity funding.
And we've seen, this proposal was presented, 423 I have. But yeah.
Yes, but we have now, what we're bringing today is the statutory language has been amended because we met with other organizations and we're trying to reach common ground.
Okay, great. But it sounds like you also need to meet with the CCB to get to a point where we can.
We do not have any control over whether the CCB will meet with us or not.
So
you asked them.
CCB has not agreed to.
We asked them, if you read the document I sent to you, attesting to the interaction in the other room, they refused. James said, I will not talk about this when he left the room. We had a subsequent conversation with Gabe in which he said, we'll talk about it, but we can't talk about cultivators and manufacturers having direct sales. And I said, that's exactly what you were asked to convene us to talk about. He then went on to talk about we need to reach market equilibrium. I said, well, that might mean hundreds of businesses going out. He said, well, farms go out of business.
Direct sales, though, is what we have at the black market. I think the reason, I think
Direct
that
sales
one
would
of
be-
the challenges we are facing as we look at this is the challenge of having created a regulated market to make it legal, and that direct sales, independent of the regulated retail market that we've created, is a challenge in a regulated market that is only 3 years old. So
With all due
have to.
respect, we disagree.
Yeah,
And-
I
and we
realize
tried
you
to bring in
disagree.
experts to
Yeah.
speak to it. Josh is the founder of the track and trace system that the state of Vermont employed for a temp program before it became a USDA program. He's very familiar with these things. These cultivators are driving product around the state. They're making sales directly to retailers. They're tracking and tracing everything. So
Right.
they can speak to this intricacies of the system. What you have not heard from the CCB is any evidence supporting the unsubstantiated remarks they've made about the impossibility of the feasibility of administering this program.
If I may jump in.
I'm gonna let Jeffrey and Graham finish, because they
Um,
don't have much.
You know, one of the valid concerns that we've heard from the board over and over is the administrative rules burden to make some form of well-regulated direct sales a reality. And we would reframe that for you all for consideration such that what's of greater value here, or perhaps consequence, and that is the understanding that we have over 400 licensed producers in the state that are fundamentally at risk. Their livelihoods are in jeopardy.
The 400 growers.
Yes, and I would include product manufacturers as well. So what is of greater circumstance here? Really allowing those 400 plus small producers to flounder and likely exit the market in the coming years, as we've seen other states go down. So we're really trying to prevent harm, or really figuring out having the CCB crack that nut, thread that needle for administrative rules. We feel like the greater burden is on allowing these small producers, right, to possibly fall victim to a business ecosystem that is not viable to them. So that's what we would return, that fair concern, and we would have all of you consider that as well. We don't think that this is impractical. We think it's obtainable, but not only that, we have done the due diligence of working with other industry groups, including Lieutenant Governor, and there is broad support for this. So we're asking you to really consider this year.
Right. And I, quite honestly, at this point, where we have to get this bill out next week, I am not sure we have the time to consider direct sales at this point.
The one thing
So,
that we
I mean,
do
I
have
think-
time to do is not get this bill out and hold it over until January.
That
That
might be
also
better.
is an option.
That's better from our perspective.
Yeah.
We do not support this bill.
We don't have to get this out unless we decide that
I'm
it's
not sure
wise for us
that's
to
the
get this
case.
out.
I would like to hear from CCB on this. Yeah.
Well, again, we're just talking about the public and
Yeah.
from our perspective. So
But we're
again,
all talking, Graham,
Yes.
that's not fair. We're all talking about our own version of understanding the public good.
I'm just saying we've demonstrated, and I'm not seeing anybody else demonstrate these things. They're coming in and saying things, but there's no evidence. We don't have anything to push against. So, limited direct retail sales temporary event. Our first priority is the social equity stuff. You heard this from the LAOB, et cetera. Limited direct sales temporary event. So this was a concession made by all the producers, manufacturers, because they really want is essentially an endorsement to directly sell on and off their premises, like a normal farm. So what they've conceded to doing is accepting temporary events, which can be held. The main concession we made here is not only are these available to cultivators, crop traders, manufacturers, but we conceded that sure, retailers can join these events as well.
So, Graham, first, before you mentioned something that the $1 million to support the business, the technical business support.
Cannabis business development.
The cannabis, so that has not been funded in this year's budget,
Correct.
is that correct?
Correct.
Would mean it essentially has been defunded.
It has been defunded. So, and cannabis businesses are not able to access all the small business resources that we have, is that correct?
Correct, and there's still what we would consider very much a green tax. So whether it's banking, insurance, or whatnot, these fees come at a higher cost than the traditional sector.
Right, so that, I just have to ask because we're in the middle of the conference committee on the appropriations bill. Did the House, because we hadn't seen this bill yet, so we were not immediate advocates on anything in the budget, quite honestly. at this point. How was that technical assistance? Because it's a technical assistance program, as far as I can tell. It was supported for 3 years, right? It's been in place for the first 3 years of this business.
Yes.
Why did House GovOps advocate for that?
That's a great question. In the past, we've seen that one-time $500,000 approach get allocated on the House side. This year, we haven't seen that. And in fact, I would just add to that conversation, both the CCB through a legislative report last year and also our coalition, we are asking for that to be $1 million.
And I think
that's fair.
Yeah, okay.
To provide the technical assistance. It's
So,
mostly-
sorry, keep going because our housing.
This is our event permit.
Good question.
You can read here,
So this is just so everybody's on the same page, this is the pilot that's been proposed, showcase event permit.
yes. So this is our language. This is not a showcase event permit. This is a limited direct sales temporary event permit. And we believe that an event itself is a pilot program. We don't need to limit the number of them. This is a pilot for on and off farm direct sales. Limiting the number of events more deeply ingrained in equities. Who's going to host those files? Who's going to get those permits? Is it going to be a lottery? Who's going to actually make any economic difference in their life from 5 potential events that they maybe access 1 or none?
I find in this role, my 5th year, it's important to take small steps. And what I think I heard I'd say is to get normalized with this and also to have staff to sort of see how this goes so that they can start to work through the rules. You don't see this as a good first step to get to the place where you want to be in the future?
Yeah. Well, my response.
I mean, well, it's better than what we have now, which is.
Sure. I mean, my response to that would be, I guess, here at BGA would be, what issues does that resolve? And we get the sort of approach of being progressive, but we have individuals hurting right now. So that's why we're leaning into, can we at least include some sort of mechanism that also is incremental in meeting them where they're at as well, whether that.
So, yeah. But Jeffrey, our understanding, and Gabe is here to help us, our understanding is that this is an opportunity for the regulated entity, which is the retailers, to pull together any number of growers in that region who would like to have direct sales at a farmer's market, at a showcase event. And it could be any number of growers that would be able to do in a regulated format, which what we care about because we've invested in a regulated market, direct sales to consumers at this kind of an event. How is this not a step forward?
That's a good question. Ethan, if you wouldn't mind, Chair, thoughts on a retailer-centered farmers market, non-farmers market event?
Sure. Thank you very much for having me. Ethan Kramer, Chili Hills, Fairfield. I just see it as, I don't see real progress here. I see it as so limited. The problem is,
but is so limited better than nothing?
I don't see it helping very many people. I see it really just continuing to help the same people who are working with the same retailers. The consumer doesn't benefit from this. The producers don't benefit from it. It's really like, it's again, a intermediary centered market. I don't know, I'm not sure which part of it seems like that doesn't make sense maybe, but.
It's a little hard to think that no one's benefiting from it when there's no opportunity at the moment to do this. However, I hate to do this to us, but we are going to pick up this entire conversation right where we are. We're going to pick it up again and we're going to do it soon. Sorry, Joshua. We need to continue this because we obviously have to get this bill out and we want very much to hear fully from indoor, outdoor, 1 or 2 indoor or outdoor cultivators. We want to finish this discussion on the showcase because actually I think some of us are under the impression this would be a helpful first step on this. And so it's puzzling to hear that it's not. So we want to have this conversation. I apologize for our time crunch. You know, this is what happens here.
Sure.
And I have to shift because we have all the housing appeals discussion here to move to.
Certainly.
And I have to get this bill out tomorrow. And it's looking like it'll be tomorrow, not today. So I want
So
to
later
pick,
this week or?
This bill you have to.
let's, Heidi and I,
Okay.
Heidi and I need, and we need to chat about that further.
Okay.
But it will be this week and or early next week, because hopefully we're gonna be done with the housing bill, and then we can turn to the cannabis bill as a top priority.
Okay, thank you, Chair. We look forward to that discussion.
I apologize.
And
It's-
members, please, will be available outside of committee if you
Yeah.
all want to ask me. questions
Great,
or have
thank you,
discussion.
thank you, and thank you, yeah, thank you, Joshua. And Joshua, would you be kind enough to also get your contact to, I think Heidi has Amy's contact, but if you make sure Heidi's got Ethan and your contact.
Yeah, absolutely.
Okay, great.
And just like, we did send you all the documents.
Yes, we have everything, thank you very much. This is terrific. And let's just pick up exactly where we are, in showcase permit.
I just want to offer for the future. We actually threw a cultivator showcase.
We worked through our break. I want coffee.
Last year.
Oh, this? Right. Okay.
2 minutes for me to get a cup of coffee?
2
No, all right.
I apologize. It's what happens when we start at 9, so 8:30,
And Chair, I feel your pain.
Stretch your legs.
There's
I am.
Thank you. Me too. I'd like to do the same.
Oh, we're.
I'm gonna